Hi, this is Anna Pinedo, and thank you for joining us for one of our Mayor Brown Microtalks. Today's topic is understanding the special securities law issues concerning special purpose acquisition companies or SPACs. SPACs have become very popular as an alternative approach for private companies that are seeking to go public. So private companies are being approached by SPACs and their sponsors as potential targets in initial business combinations. By entering into an initial business combination with a SPAC, the private company ultimately, once the initial business combination is completed, would become a public company and would be the continuing operating company following completion of the initial business combination. For many private companies, merging with a SPAC seems like a relatively quick, cheap, easy alternative to undertaking it rather than undertaking a traditional IPO. It's important, though, to consider some of the special attributes or special treatment accorded to SPACs under the US securities laws. These are particularly relevant to the private company as it's weighing its options and as it's thinking about whether to conduct a traditional IPO or to undertake an initial business combination with a SPAC. A lot of these issues that I'm going to go over are also important to the existing stockholders of the private company because they'll affect the private company's liquidity going forward, and they'll affect the ability of the existing stockholders to resell their securities in the public market following completion of the initial business combination with the SPAC. So I'll go through a handful of these. First off, emerging company status. An entity that qualifies as an emerging company is able to benefit from a number of accommodations under the securities laws. Principally, the EGC can benefit from disclosure accommodations, a need to present shorter financial statements, to omit certain executive compensation disclosures, as well as corporate governance accommodations. For example, the ability to defer the Sarbanes-Oxley Section 404 attestation until when it ceases to be an EGC. So typically, a company can remain an EGC until the 5th anniversary of the consummation of its IPO, or such time as the market value of the common equity held by non-affiliates exceeds $700 million as of the prior June 30 or second quarter fiscal end. It's important for a private company to take into account that a SPAC may have gone public as an EGC, may remain an EGC for some period of time, but by the time it completes its initial business combination, some of that 5-year period that I referred to may already have run. As a result, the private company may not have the full benefit of the 5-year period for EGC status. So that's something to take into account. SPACs are often referred to somewhat incorrectly as blank check companies. A blank check company under the securities laws has a particular definition. So a blank check company has to issue penny stock. And under the securities laws, under Rule 3A51-1G, a company can be excluded from the definition of a penny stock issuer if it has at least $5 million in net tangible assets. So generally, a SPAC will endeavor to avoid being considered a blank check company because the securities of a blank check company would not be able to trade, and obviously immediately after it completes its IPO, a SPAC does want its common stock and its warrants to trade. So usually a SPAC will file a Form 8K shortly after completing its IPO, where it will show an audited balance sheet recording the amount of assets that it raised or the amount of capital that it raised in its IPO and avoid being considered a blank check company. So as a diligence matter, it's important to make sure that indeed the SPAC went ahead and did so. Now, even though a SPAC can avoid being considered a blank check company, it will be considered a shell company for Securities Act purposes. Shell companies are defined in Rule 405 under the Securities Act. There are a number of difficulties that come with being a shell company. One of those is that a shell company is considered an ineligible issuer. And that means that because a SPAC is going to be considered an ineligible issuer, it's going to be limited in the types of communications it can engage in. And even after the initial business combination and for a period of 3 years from the date of the business combination, it's going to remain an ineligible issuer. So for so long as it remains an ineligible issuer, the SPAC cannot benefit from the ability to use a free riding prospectus. It also has to make sure that it conducts all roadshows as live roadshows. Now, these can be virtual, but they have to be in real time. They can't be recorded. They can't be considered written materials. That's very important because oftentimes companies that want to do follow-on offerings will tape a roadshow presentation. Companies also enjoy the ability to use a free riding prospectus. So it's important to keep in mind that a SPAC or a former SPAC will not be able to do that. Related to that, an ineligible issuer can't be considered a well-known seasoned issuer, or WICSI, again, for the 3-year period following the initial business combination. Despite perhaps having the public float that would qualify it for WICSI status, it simply won't be able to benefit from that until it ceases to be a shell or former shell company. The other things to think about is that a number of the other communication safe harbors that are available to issuers are not available to shell companies or former shell companies. So for example, communications safe harbors that exist under Rule 163A. So those are for communications that are made 30 days prior to the filing of a registration statement, as well as the research safe harbors, which are regularly relied on by investment banks that produce equity research. So those are Rules 137, 138, and 139. As a result, the investment banks that cover the company may be somewhat limited in terms of when they can put out research reports and whether they can put out research reports in or around the time of a follow-on offering. Finally, another thing to think about for stockholders of a private company considering merging with a SPAC is the ability to rely on Rule 144. So a holder of SPAC securities cannot rely on Rule 144 for its resales until a full year has elapsed from the completion of the initial business combination. And then Rule 144 is only available to the extent that the entity has filed all of its periodic reports required under Section 13 or Section 15 of the Exchange Act for the prior 12 months. So that may be an impediment, and it explains why so many SPACs file resale registration statements to cover the resales from time to time of the securities that were issued in the initial business combination to private company stockholders. So those are just a few of the things to take into account if you're a stockholder of a private company or management of a private company and thinking about merging with a SPAC. If you'd like more information on SPACs, transactions involving SPACs, and some of the securities law and capital raising issues, we encourage you to visit our blog, Free Writings and Perspectives, for more information on all of these topics. Thanks so much for joining today.